Oh, look, Ramel's here. I guess Roselle left. The next topic, I usually apologize before I talk about it, mostly because when you were planning on going into claims handling, you probably didn't say, boy,
Who planned to go into claims?
Exactly. I too was sentenced to this. But one of the reasons we do it is because we want to avoid at all costs math.
Right. Well, then
And the next topic has more math than all the other topics we're going to talk about today combined, or added, or using the combined values chart. But it is probably one of the most important topics if you have claims of this nature, because what we're talking about is life pensions. Now, once again, disclaimer, I've said it before, the presentation is for educational purposes, and should you require specific help on a specific claim, we would need to know specific facts. But the information here you can use to evaluate claims. Life pensions. Who would like to define it for me? Okay, Heather.
Reverend ever. And some more.
Life pensions are just one of the indemnity benefits we pay in workers' compensation. Now, because I'm a geek, I think about these things in terms of indemnity versus, say, medical treatment. Indemnity is money that goes to the applicant. Medical treatment is money that goes to other providers on behalf of the applicant. So indemnity consists of, what are the usual benefits? Temporary disability, permanent disability, death benefits, partial disability, and life pension. And what do all of these benefits have in common?
They go on forever.
It's based on salary.
They're all based on salary, absolutely correct. What else? They're all paid weekly or bi-weekly, depending on what benefit you're paying. But the point is, we don't owe temporary disability ad infinitum. You understand? We owe it while we have medical evidence indicating that we have temporary disability. Now, they're all based on the average weekly wage. We all know how to calculate that, but I've given you the code section here anyway, just in the event that you have questions about the average weekly wage. Temporary disability, there's no question that we know all about that, right? Feel free to nod. I know lunch puts you a little bit on a relaxed day. But temporary disability, we have to have medical evidence. We don't pay benefits unless we have medical evidence. Permanent disability, we have to have some type of finding of permanent disability, and we also have to have some type of a rating. I think I even gave you an, we'll come back to that, but we have to have a permanent disability rating outlining how much we owe. But it's still based upon the wages, okay, you're all asleep now. It's all based upon the maximum rates are based upon the date of injury. And we calculate based upon their average weekly wage. And so if you look forward, you'll see that every year has a slightly different benefit. And until, what was it, 2013, it was all quite easy to follow because the maximum rate was $270. The lower rate for injuries under 70% was what, 230 or 240? 230. So it was all easy. But when we're calculating benefits, frequently we err by not paying attention to the year in which the injury occurred and the rates that apply, or we don't pay attention to the fact that maybe they're not a maximum wage earner. So before we get on to life pension, we all know how to rate. We all know that based on the body part, a standard, a rating factor, we all know that since 2012, is it? 13, it's all using a category 8, a 1.4 modifier. So the rating is not the problem. The problem that we have is the table. Now, I was kind enough to bring you some supplied by CD Photocopy, and these are wonderful tables. But these are tools. These are not the absolute gospel. So when you look at a rating and you see 52%, we do not owe $83,000. What we owe is $270, 52, $230 for X number of weeks. You got that? It sounds silly, but we look at the tables. We look at them, we go down, we find the number, we scroll across, and we see 26%. We go, oh, that's $30,000. We see 71%, we say, oh, that's $130,000. But it's not. If the applicant dies tomorrow, we owe 1 day of permanent disability. If the applicant dies 6 weeks into benefits, we owe 6 weeks. So even when we're thinking about how we pay benefits, we have to take into consideration that all indemnity benefits are owed only 1 week at a time, or 2 weeks at a time, bi-weekly benefits, okay? Is that pretty simple? I'm hoping so. Life pension is when the benefits get in excess of 70%. It's merely a lifetime benefit that will be paid to the applicant once his permanent disability exceeds 70%. Remember my discussion of injury earlier, when I was talking about trying to split up CTs so that we could keep them under life pension? If they're over life pension, they'll get a full permanent disability award, and then they will get additional money the rest of their life. And that money is ever increasing. So let's start off before we talk about that. How do we calculate the life pension? Well, it's a simple math problem. You take the percentage of disability, you minus 60%, you multiply it times 1.015, and then you multiply it times their average weekly wage, not to exceed $515.38. Say, gee, Jim, that sounds quite easy. Just memorize it, it's easy. Thank you. It's not difficult to calculate. Where the difficulty comes in is evaluating what the life pension is worth once you know the weekly value. Okay? Let's move on. Let's talk about an example of life pensions. And when I actually put this presentation together, I wrote it out. I said you have applicant with a February 2013, blah, blah, blah. And as I kept reading this over and over again, I said to myself, this makes little sense to me. So what I do is I draw pictures. So let's go with the pictures for a moment. Depending on when your PD start date is, you will pay so much money up to the P&S date, you will pay to the completion of PD, and then you will pay the life pension thereafter. Is that pretty easy? And the purpose of these slides here is to show you that if you have 10 years worth of accrued benefits prior to P&S at an 83% permanent or 86% permanent disability, you will only have 3 years after permanent disability or permanent stationary finding before the life pension kicks in. Is that pretty clear? Whereas if you only have 3 years of accrued benefits, you will have 10 years worth of permanent disability payments before the life pension kicks in. So depending on where you set your PD start date will dictate how much the life pension is worth. Now you may say, Jim, how do you vary that PD start date? Well, one way is when you're filling out the stipulations, write a date later than it should be. Because technically PD starts after 2 weeks after temporary disability ends. Now, we don't have to pay it then, but when we pay retroactively, once we have a P&S date, we're supposed to pay all the way back to that point. But we can use other artificial dates. For example, if they have different P&S dates, we can use other artificial points to indicate a PD start date. Or maybe in this example, the person returned to work. In the top example, the person returned to work and we didn't know how much PD they would have. and their injury continued, or their treatment continued on and on for 10 years. I've had that claim. I think I still have that claim. Wondering if it'll ever go away. But depending on when you start the permanent disability, it will dictate how much a life pension ultimate value is. Because a life expectancy generally doesn't change. And when you're looking at this, you have to ask yourself also, what is the applicant's rated age? Is everyone familiar with the rated ages? Okay. The best example I like to give of a rated age is a person with a terminal cancer. Maybe a 57-year-old person has a life expectancy of 13 years. That's the 97-year-old, right? Yeah, the 71-year-old. But with cancer, that life expectancy is significantly reduced. That's the rated age. It's the significant reduction based upon whatever physical ailments they suffer. And so when you're calculating the value of the claim, you want to know the rated age because combining the permanent disability with the life pension reduced for a rated age will give you a lesser amount of money. Is that fairly clear? I see some yeses, I see some nos, I see some people barely awake. Look at this example here. With a life expectancy of only 13 years and an 86% rating of 13 years, this person would not likely get a life pension. Although the injury warrants a life pension, their life expectancy doesn't extend to a point where they were actually collected. So if you're talking about settling this claim and the applicant attorney is valuing the life pension, you want to make sure that you take into consideration that the life will not extend into a life pension period. It will not likely extend. It may. People live longer than the life expectancies. Is that clear? Here's the math part. When you are calculating the value of a permanent disability with life pension, you need to figure out when that PD start date is. And then add up your benefits all the way through the P&S date and subtract those weeks of permanent disability from your rating weeks. Is that clear? If you look at your charts, you always have a column that says number of weeks that PD is payable. So your accrued weeks, you'll subtract from that number, and then the remaining weeks, you will subtract from applicant's life expectancy, and then multiply his weekly life pension rate, which we all know is calculated by taking the PD amount minus 60 times 0.015 times up to 515.38, times the remaining life expectancy weeks. Does that make sense? Does anybody at all understand what I'm saying?
No.
Okay.
We hear you speaking English, but it's not computer.
I told you it was math, and I told you it's not the most pleasant topic that we get to talk about. The key is we have a fixed life expectancy. If we subtract out our age and the benefits paid, whatever is left is payable as a life pension. And we take that time frame and we multiply it times the life pension rate. Somebody's nodding. Okay. That life pension rate, though, is adjusted by the cost of living adjustment. Okay? Now, we use in California, we use the state average weekly wage, which I gave you the definition here. It's the wage paid by employers to employees covered by unemployment insurance as reported by the United States Department of Labor for the 12 months ending March 31st of the calendar year preceding the year in which the injury occurred. That all sounds nice, but all that is an adjustment factor. They could have used the interest rate relied upon by the feds. They could have used the unemployment rate. They could have used any number they wanted. They chose to use the SAW rate to provide a cost of living adjustment to applicants' benefits. And because we have this now, permanent total disability benefits as well as permanent life pension benefits are now going to be increased as the case ages. Now, COLA benefits also Cost of living adjustments also impact temporary disability, and they also impact death benefits. But in those benefits, they impact the rate, whereas on life pension, they impact the actual benefit. Now, what's the difference? If you have a maximum wage earner for temporary disability, or somebody who is getting death benefits at the maximum rate, and the COLA adjusts up, then they will get the adjustment. They will get the increased benefit. If you have a less than maximum wage earner for temporary disability or death benefits and the COLA adjusts up, they do not get an adjustment. Do you understand? Maximum, as long as the rate increases, they get the increase. Less than maximum, they do not get the increase. Minimum, however, does. If they're a minimum wage earner, they do get the benefit of the COLA increase. With life pension, whether or not they're a maximum, every January 1st, they get an increase in their rate. So you mark it for January 1st and you see if there was a SAW adjustment, and then you adjust their rate based upon that SAW, that cost of living adjustment. Do you understand? Heather?
I said, I understand. I just haven't done it.
I knew you would. I'm picking on Heather because I know Heather. Now, as you'll see over the last several years, SAW has ranged anywhere from 0.7 up to 5.5. Over the last 50 years, I understand the SAW adjustment has averaged right around 4.6. But over the last 10 years, it's averaging closer to 3. So which SAW adjustment do you use when you're calculating benefits? Well, that's open to interpretation. You can use a 3%. You can use a 4.6. You can use a 5. But that'll be for reserving purposes. Clearly, if you're talking about settling a case, you're going to use the lower rate to estimate the value of the life pension, correct? Lower life pension, Bueller, you. You'll see from these cases, the Baker case and the Brower case, that benefits start after the end of TD. So even when you might have delayed starting permanent disability for some number of years, especially permanent total disability, if you go back and you pick up a retro benefit, the COLA starts the January 1st after you started, even if you started paying 6 years into it. Do you understand? So if you started paying your permanent total disability or 6 years later, 6 years from the end of TD, they will get the COLA adjustment for each of the 5 years up until you picked up benefits. Because COLA adjusts on January 1st of every year. Now, at least 1 year I've been in existence, it was 0. There's no change in the rate. But every other year there has been a change in rate. And so we have to know what that change is and adjust the rates accordingly. The Brower case simply says that when you end temporary disability under the 104-week rule, just like any end of temporary disability, permanent disability starts 2 weeks later. So it exists no matter what. Now, there are circumstances when we're not going to pay permanent disability right away, when we can't estimate our reasonable estimate, or if they return to work. But when we eventually have to pay it, we have to retro back to that end of TD date. Make sense? The American Safety case. Basically what that says is exactly what I told you a moment ago. For life pensions less than maximum wage, they still get a COLA adjustment. Whereas on TD or death benefits, if they are less than maximum wage earners, greater than minimum, they do not get a COLA adjustment every January 1st. The Wilson case is important for every applicant attorney. They get their fee. If there's a life pension involved, they want COLA calculated because they want to take as much as they possibly can from the applicants. Now, for the most part, I don't care. It's not, I don't get into that relationship. I'm not trying to separate the applicant from their attorney. But you will see that down the LA Metropolitan case, the board found that a 3% rate was appropriate rather than a 4.6 rate. Now, the significance to us, probably pretty minimal. We don't care where the money goes. But to the applicant, you think they were asking for 50% more than the board awarded. They were asking for an increase in their fee, at least against a life pension, by 50% more. And over time, that compounds and becomes quite a large sum of money. So when you have COLA benefits involved, remember, always go into effect January 1st. And we do have to consider it with attorney fees, but we do not have to consider it for really greater than 3% as an adjustment factor. Wait a minute, you just asked that question. When does COLA take place? Okay, it's test time. Lorna, if the life pension began on December 30th of a given year, when do we add the COLA into it?
January 1st.
Absolutely, of the next year. Valerie, if the life pension began February 7th of a given year, when does the COLA change take effect? January 1st of the next year. No matter what, it is always January 1st. So at January 1st, any life pension claims, any death claims, any permanent total disability claims, you want to adjust. However, you don't adjust temporary disability claims every January 1st. Why? Two-year rule, 4661.5. If you are paying temporary disability more than 2 years from the date of injury, you do have to adjust the rate, and you would adjust it based upon the rate in existence at that time. But until then, the first 2 years, you do not have to adjust their temporary disability rate at all. All pretty easy? I think I just said this too. Okay, you don't need to hear it again. Let's go to commutations. How many of you have taken out a house loan, car loan, personal loan? Okay, first there was only one of you, it scared me. But now I see there's more than that. Whenever you borrow money, you pay interest on it, correct? Commutation, they're asking us to pay money that we do not owe. Remember, we only owe permanent disability for the next 2 weeks. We do not owe for the next 13 years if it's 86%. We owe 2 weeks. So when they ask us to pay early, when they ask us to commute part of their award, we're entitled to interest on that award because we're paying it early. That's what a commutation is. People get confused about commutations. Commutation is simply a discount we are given because we are paying money we do not owe before we owe it. Now, what's the rate of commutation? Traditionally, it's been about 3%. The commutation tables in the back of your labor code are based upon 3%. But a commutation is simply a discount that we are taking so that they get their money earlier. Is that okay? Is that pretty clear?
Ask a question.
Absolutely.
If you have somebody, let's say you have an award, it's 60%, you start paying it out, but you inherit a claim and the commutation was never done, can you do that commutation at any time, or does it have to be done at the time that you start paying out the award?
Now, I'm going to repeat your question only so that the home viewers can hear it. If you inherit an award and there was a commutation, usually of attorney fees, correct?
Correct.
And it wasn't done at the time of the award, can you do it at a later date?
Yeah.
You can calculate it at a later date as long as the award indicates that commutation is appropriate, but you have to calculate it from the date that the benefit was paid.
Right.
You can't calculate it from the date that you took over because there would be a different discount because more money had been paid by that time. And we're going to get to that in just a moment, I think. Commutations, other than attorney fees, are always in the best, or let me rephrase that. The board looks to see if they're in the best interest of the injured worker. You'll have lots of people, I'm going to show you some case law in a moment, where they're saying, well, I can invest the money better than the insurance company can. I can take care of this better than the insurance company. Give me the money. And the board says no. That's not a basis to get the money. They are looking to see the best interests of the injured worker, whether they can survive on whatever's left after the commutation, and how much they want. Recently, I actually read a piece of case law where a woman asked to commute a large sum to buy a mobile home. And the board said no, because they felt that after she had bought that mobile home, if she could not maintain the payments, her reduced PD amount would leave her unable to get an apartment or anything else. So they felt that she would be worse off after the commutation. And you'll see in here as we go through some of these cases, you'll see that the board does try and take into consideration the best interest of the applicant. Now on this page I mentioned that the most common type of commutation, attorney fees. There's different types of commutations. You can commute from the far end of the award. You can commute from the near end off the side of the award. And there's two ways to do that too. We're going to get to that in a minute. The most common, however, is the commutation off the far end of the award. And if you have a life pension, that will create a gap between the end of permanent disability and the beginning of the life pension. So applicant will go without money for a period of time because his attorney got paid early. Now, when I was put together this presentation, I saw that you can commute all or part of a permanent disability award. You can commute all or part of a life pension award. You can commute all or part of a death benefits award, and you can commute all or part of a permanent total disability award. I have never seen a permanent total disability award commuted in its entirety. I don't know how you're going to calculate that. I mean, you just take the life expectancy, the rated age, and calculate that to a lump sum. But if you have a permanent total disability award and there is a commutation issue, the law has allowed it in the past. Remember that thing about the gap? Here's my visual representation. The same example as before, 86% PD, 28.7 life expectancy. After the PD is paid, there may be a significant gap between when permanent disability ends and when life pension begins to represent the commutation, the commuted amount. It is because of that significant gap that applicant attorneys may ask that their fee be commuted off the side of the award. And when you commute it off the side of the award, what you do is you reduce the weekly amount so that every week the applicant gets a little less money, but there's no gap at some point in the future. Understand? It's just different ways to come up to the same solution. I gave you a series of cases here. You'll see that a lot of people are asking to buy homes. And the board really does make an effort to determine whether it is in the best interest of the employee. Weston, she wanted to buy a home. Sonora wanted to buy a home. Hood wanted to buy a home. O'Hagan wanted to buy a home. Are we seeing a theme here? But when you go down, you will find, I'd like to talk about the Jenkins case. Is it up there now? Yeah. They provided commutation for a terminally ill widow who was collecting the death benefits from her husband's death. And they did it for anticipated hospital and doctor drug bills. And they gave her the money so that she may enjoy the uncertain period of time that she has remaining with respect to life. I'm trying to picture the claims examiner who had a terminally ill widow saying, no, you can't have any of that money now. You're going to continue getting the $224 a week until you pass. the board tries to take this into consideration. Oh, by the way, with commutations, they're not automatic. These cases show that people have had to litigate these commutations. When you get a request for a commutation, you yourself can make the decision as to whether or not to grant it or not. Now, calculating the value of the commutation or how it's going to be done, that's a different story. But you can decide when you get a request for a commutation, usually other than an ordered attorney fee, you can decide, I think that's reasonable, I want to give the money, or I think it's unreasonable and I don't want to give the money. Clearly, if it's for a house for somebody who needs a house. But you'll also see 2 or 3 cases here where they decided they were trying to offset the effects of inflation. Up there, the Umholtz case, there's at least one other that way, where they said, no, that's not your option. And besides, if you got the money and invested, and the investment went sour, you're now out a larger sum of money than you had been had you just left it with the insurance company. Does that make sense? The Price case, another of my favorites here. Applicant attorney asked for a award, a commuted award off a STIP when the applicant had died. There is no money to commute it from. Remember, indemnity benefits are paid for specified periods and PD ends with your life. You die, you get no more. So we can't commute a fee when there's no more money that exists. And what is 3% of 0? Down here at the O'Brien case, they had a life, or they awarded it when they demonstrated sufficient evidence of the pressing financial need and just of his pressing financial need. You will see further on that they do not require any specific documentation. They do not require a specific petition for commutation. What they do, however, require is some evidence that you have that financial need. In the past, when I have had petitions for commutation come in, they'll tell me, this is to pay off bills. Show me the bills. They say, well, that's none of your business. But you're absolutely right, it is none of my business, but I don't have to advance the money. I don't have to pay. So, although there's no specific form required, no specific petition, you are entitled to documentation as to what the money will be paid for. Make sense? Hey, that's the quarry case, isn't it? And the city of Foster, or the city of Foster City, that is the case that established that off the side of the ward is frequently better for the injured worker because it's better to reduce a few dollars from his weekly payments than to leave a gaping hole in his payments in the future. So he'll have to figure out how to survive for anywhere between weeks to years, depending on the size of the award and the size of the attorney fee, before he gets paid. Now, I was going to sit here and work you through a commutation line by line by line, because I know that is what you came here for. I know you say, I have not done nearly enough math, and I need to do this. But I have provided you with a website, and that's a board website. And that will lead you to an Excel spreadsheet where you punch in the relevant data, and it gives you the commutation. There are 8 different spreadsheets for commuting all of an award, for commuting part of an award, from commuting it off the end, from commuting it from the side. So if you take nothing else out of here, take that website with you so that you can do the commutation yourself when you're trying to figure out a commutation. And, because I like saying this, it also documents your file. If you have documentation that that is how you calculated the commutation, we can defend it. But as in your case, even in your case, you can go backwards and use the spreadsheet using the dates from the award to calculate what would have been chopped off. You just got to make sure you put in the proper dates. And how do we know the proper dates? Well, the date of the commutation is not necessarily the date you're doing it, but that's the date when you're going to change the payment. Okay? So you don't want to do the date of commutation identical to the date that you're calculating it, because you don't have time to effect the payment change yet. So when the board does it, they will usually run the date of commutation out 30 days. So that you have time to schedule a change in payment rate. You understand? Commutation calculations, we talked about that briefly. COLA considerations, you may want to factor in how COLA will affect the outcome of the changing rates. Commutation concerns. Many people don't like commuting because we're giving applicant money they're not entitled to yet. And if they die, we're simply out the money. And it's true. If they die, we're simply out the money. But at least when it's ordered by the judge, we have to do it. We have no choice. I'm not going to talk a lot about the different commutation methods. Well, I'm going to talk a little bit about it, but only in a calculation method. But it's easiest to commute off the far end of an award. That's where you reduce the award. The mathematics is a lot simpler. I've given you an example with numbers, which I'm not going to go over in detail. But like I said before, when you're calculating the value of a case, you have to figure out the value of the remaining benefits. This is where your question comes in. Because if you didn't do the commutation till, say, several months after the award, the remaining benefits are different than they were at the time of the award. Do you understand? So if you're going to do a commutation then, you have to go back and figure the amounts from the time the award issue. But you take it from that point, and then you set yourself out a day for the commutation so that that's the date that the rate change will take effect. And then you punch in the numbers, you come up with a balance at the end, and you know how many weeks will be deducted from the far end of the award, and how much will be paid. It'll also help you calculate your savings. When you get to commutations off the side of the award, it becomes more problematic because there are different ways to do that. They have the uniform reduction method, and they have the increasing reduction method. What's the difference? Well, one has uniform in the name, and the other has increasing. Just making sure you're awake. With the uniform reduction method, once you've done the math using that website and gone to the right table, that amount will be deducted from every life pension payment going forward, no matter what year it is, no matter how the COLA changes. Do you understand? So as COLA increases the life pension award, the reduction amount will stay the same every time. So you can imagine with the increasing reduction method, there's a difference. As COLA changes over time, the increasing reduction changes over time. Now there's a whole complicated math formula for figuring that out, but you will find that at that website. And then every year thereafter, you will make the adjustment for both the increasing rate and the increasing COLA adjustment. Or you'll just have the board rater do it for you if it's really complicated. However you do it, you want to make sure you have it listed in your file what's going on. It's documentation. Without documentation, we fail. Without documentation, our payments are unreasonable. And I promise you, no matter how you calculate it, if it's calculated on paper, we can defend it. Does it make sense? I talked about the uniform reduction method. I talked about the increasing reduction method. I cannot say this enough. I mentioned it during the case law cases. When you are doing any settlement document, you want to make sure that you have the right benefit rates. I do not know what types of claims you handle, but I handle everything from long-term employees in a construction environment. I have teachers, I have public safety officers. I also have temp employees who will work a job for just a few months, and they won't even be, they'll get minimum wage at best. So you need to know the rate, their average weekly wage, because that will dictate all of their indemnity benefits. And if you look at that case law book that, I didn't bring it up, but if you look in that book, you will see every time defendant has made an error as to the rate, recon is denied, and the applicant gets the benefit of more money. Every time. When you're going to do a COLA adjustment, be aware of the date your benefits begin. Because if they begin before January, and you're going to have to go through a January, there's going to be an increase. Doesn't matter if it was December 31st that you start benefits. January 1st, there's an increase. Life pension rates, just like all indemnity rates, are based on the date of injury. So check the table. I gave you the table with all the different rates. Currently, the maximum is 515.38. For years and years and years, it was 257.69. So it was easy to remember. And like everything else, they changed it to make it a little more complicated for us. I don't like to say this, but for truly complicated commutations, I do recommend that you go to the DEU. The better documentation you have in the file, the less likely you are to get into some kind of a trouble because of that documentation. Does that make sense? Now, I will tell you that for the most part, the DEU uses the same tables that I've referenced here. They'll use the exact same table for the commutation, but at least then you have the applicant attorney with you, usually at the board. They'll look at it and they'll agree to it. And then you have a stipulation as to the correct numbers, the correct rates, rather than just your own calculations. When you're talking big money, you don't want to make big mistakes. Big mistakes result in big penalties. And that we want to avoid at all costs. Questions? Absolutely, go ahead.
Maybe this is looking for something too simple, but on a benefit that reduces like uniform. Is the COLA based on what the amount would have been prior to, or the actual amount issued?
The COLA increase applies to the COLA begins the January 1st after you start the benefit. So let's take a life pension. Use my example where we have 13 years. There is that 13 years, there is no COLA adjustment to the life pension. It's only when the life pension kicks in that then the next year the COLA benefit increases it. Now, if you're talking
the original rate, or is it the reduced rate as a result of the commutation?
now, if we're talking
Which rate is increased?
The pre or post side commutation on the side?
Well, if you're doing it from the side, that depends on whether or not you're doing a uniform reduction method or an increased uniform. Uniform, you go back, you take the original rate, COLA adjust it, then subtract the amount. The next year you take that rate, COLA adjust it, subtract the amount. The next year you take the rate that you had in existence, COLA adjust that, and subtract the same amount. Do you understand?
So on the pre, so your statement is based on the pre-uniform reduction rate?
Correct.
Okay.
You do not use the reduced rate to calculate the COLA. You use the full rate, and then you subtract the uniform or the amount from it. Does that answer your question?
Yes.
Now, where that differs from the increasing reduction rate is you agree upon a factor for the commutation, and every year that factor changes the reduction amount. That's the increasing part. So you go back to the original rate, you calculate the COLA adjustment on that, you calculate the factor on your reduction, and so each of them increase a little at a time. The benefit of the increasing reduction rate is it starts off with a smaller reduction from the life pension. That's the benefit. Did I see an arm? Did I hear a question? Are you still awake? Well, then thank you, and I'll end.